All right. Very pleasant good morning to everybody. Thank you for joining us today for Trident's and Kaye Bender Rembaum's collaboration on the Conflicts of Interest, What You Need to Know session. Good for an HR credit if you're a manager, or an elective if you need an elective. Vital information for board members. I'm Jeff Solomon with Kaye Bender Rembaum. You probably see Jason Schoenholtz with Trident. We'll introduce Trident, our host, in about a moment. We're going to give it another minute for our attendees to populate. We have a few hundred of you with us today. Thanks for spending your time with us, and we'll be back in about a minute to get us started. Thanks again. Okay, the numbers have slowed a bit. I want to do a quick little bit of housekeeping before we get started with our conflicts of interest class today with our host, Trident Management. Thank you for having us, by the way, Jason. We appreciate you. Y'all are wonderful. Towards the end of the webinar, we're going to place a link into the chat area. And when we do that, that is how you're going to get your certificates and prove you were with us for the entire duration of today's session. So if you're a CAM board member, please fill out the evaluation, not only for attendance and for certificates, but we also want to know how we're doing and what we can do to serve you better going forward with regards to education and offerings. So when you fill this out, we'll have the link in the chat. You press that link, it opens up in a tab. You fill out this evaluation here, and then the confirmation submission screen, after you hit that submit button, takes us to a screen that looks like this. You will then be able to click this link to activate your certificate, download it, and save it. Just beneath, and I'll go over this again later. I know I'm doing it quickly now. You'll be able to click here to download the slides that Michael will use today for the presentation, as well as everybody's contact information. So we'll go over that again a little bit later. And one final note before I kick it over to our host for today, the chat has been disabled. We will be using the Q&A feature at the bottom of your screen. So if you don't have that up yet, you can hit the Q&A button at the bottom of your Zoom interface. And that's where you will type in your questions. And we ask that you please keep everything on topic today and not too association specific, because we do not have your documents in front of us. So with that said, I want to now turn it over to our hosts, our gracious hosts for today, Jason Schoenholtz from Trident Management. Thank you so much, sir. Take it away.
Thank you so much, and thank you everybody for joining us. As they said, I'm Jason Schoenholtz. I'm the CEO of Trident Management. We're a Dade County-based management company servicing Dade and Broward County portfolio and on-site management. We thought this was a particularly pressing course, an important course to take on today, especially considering there are some proposed changes in the legislature that'll affect this even greater. So it's something we all need to talk about and be prepared for as a whole. So with that, I want to introduce Michael Bender, who was kind enough to give today's class and keep us all in line.
Well, thanks, Jason, and thank you to Trident for hosting the program today. Hello, everybody. I'm Mike Bender with Kaye Bender Rembaum, Community Association law firm. We welcome you to the next hour, where we'll be talking about conflict of interests, what you need to know. And this is going to be pertinent to both the condominium, the cooperative, as well as the HOA directors and managers that work with all of these community associations. As Jeff mentioned, we are asking if you're going to throw any questions out, please do keep them pertinent to conflict of interest. I'll do my best to try to get to questions. I want to make sure I hit the materials and get through the materials. There is a lot to go through. And like I said, though, I will try to get to the questions as best I can. Really, we're going to jump right in. And Jason, again, I want to thank you guys as we go through. Jason, please do feel free to jump in anytime. You have, from a management company's perspective, if you have things to add on a day-to-day. What I'm going to do is I'm going to try to share my screen, and hopefully you guys will tell me it's working.
We know you've got this.
Let's see.
Perfect.
Excellent. Excellent. Okay. Now it's a matter of how does it move? There we go. Love technology. All right. So first thing I want to get into, guys, is community associations. Your HOA, your condo, they are corporations. As you all know, they're, for the most part, they're not-for-profit corporations. And for those of you who serve on your board, you are officers or directors of a not-for-profit Florida corporation. You are running a company, a business. Okay. So are you allowed to receive a salary or compensation as a director or officer, or is it something that is just part of the job? And the law in Florida is very clear on this. Okay. Under 718 Condominium Act, okay, unless otherwise provided in the bylaws, members of the board shall serve without compensation. And unless otherwise provided in the bylaws, the officers serve without compensation at the pleasure of the board. So in most communities that we work with, and Jason, you could share your perspective as well, but most communities that we review, when we are working with, we are seeing where the bylaws do not provide for compensation to board members. I've even had a few where when they go through amendments, one of the amendments that the board wants to promote to the membership is removing any indication that there will be compensation for a director and or officer. But the statute in 718 is very clear that unless you provide, it's otherwise provided in the bylaws, you're serving without compensation as directors and officers.
Yeah, I've been doing this 24 years now, and I don't think I've ever seen a set of bylaws that allow.
Right. And now the HOA, a little bit more wordy, if you will, but same premise. A director, officer, or committee member may not directly receive any salary or compensation from the association for their performance of duties as a director, officer, or committee member, or in any other way benefit financially from service to the association. There are certain exceptions which make sense. For example, if there's insurance proceeds that are recovered from an insurance policy that benefits all the members. If there's fee or compensation authorized in the governing documents, very similar to what we just talked about in the condo world. I do want to point out that what we're talking about is a director or officer being compensated for the services they're providing as a volunteer director or officer. That is different than a director who, say, owns a landscape lighting business. And the association decides that they are going to hire this director to do this director's company to do their landscape lighting. I'm going to get into some of the conflict of interest requirements in that scenario, but do understand that is not something that is being addressed by this compensation language. This is generally very specific, this is very specifically talking about whether you can receive compensation for the services you're providing as a volunteer director or officer, okay? And as Jeff mentioned, all of these slides are going to be sent to you. And we think that we put something together, which is a real good education tool for you to refer back to. Okay. Now, you've probably heard a lot of this as directors, fiduciary relationship. Okay? Both 718 and 720, 718 your Condominium Act and 720 your HOA Act, Homeowner Association Act, do have language that references the fiduciary relationship that you have to unit or lot owners, which means you must act in the best interests of the association. Okay, so what is your duties as a director? Okay, Chapter 617 of the Florida statutes. This is your not-for-profit corporation act. Okay, all community associations, and we're going to presume that they're all not-for-profit for purposes of this discussion. All not-for-profit community associations, your condominium, your cooperative, your HOA, are also governed by Chapter 617 of the Florida statutes, which is your Not-for-Profit Corporation Act. So what that means is that if there are provisions in Chapter 617 that govern how the corporation is to be run, and they do not conflict with any provision in 718, 719, or 720, then the language of 617 is also going to be applied to the organization, to the corporation. If there is, in instances where there is a conflict between 718, 1920, and 617, the language in 718, 719, or 720 will control. We're not finding that conflict here, though. In this instance, we're talking about Chapter 617, Section .0830, and this is director duties and potential personal liability. And it's very simple. It basically says a director shall discharge his or her duties as a director, including if you're a committee member, in good faith, with the care of an ordinarily prudent person would in a like position would exercise under similar circumstances, and in a manner that you reasonably believe to be in the best interest of the corporation. So it's reasonable belief as well as, and the care of an ordinarily prudent person. So they're comparing you, these are the standards you're following. Okay. In discharging these duties, the director may rely on information, opinions, reports, or statements, including financial statements, that have been prepared or presented by the following three: an officer or employee of the corporation, whom the director reasonably believes to be reliable and competent in the matter presented, legal counsel, a public accountant, or other persons as to matters the director reasonably believes are within the person's professional expert competence, or a committee of the board of directors of which that director is not a member, which you reasonably believe the committee merits confidence. So you can see there's a common theme. You can rely on fellow officers of the corporation, committee members of the corporation, or your experts, so long as you reasonably believe that the information you're relying on from the individual presenting it is reliable and competent.
I think this is important, Michael, because directors feel like they have to know all things, and that's just not a reasonable expectation of them. But this is pointing out that if you're relying on that, opinion of a trustworthy expert, which is what you should be doing, because this isn't necessarily your day-to-day business, that this gives you that support in doing those things.
Right. And again, and what I'm this is a foundation I'm laying for essentially business judgment. Okay? Because ultimately, what Jason and I are talking about is board members, you are entitled to what is a legal document is a business judgment rule. That's a legal term, and what the business judgment rule essentially is something that, as what I just described in the prior slide, it's where you're reasonably relying on information being presented to you by individuals who have a, again, I'll use the word reasonable perception of having an expertise or at least a background in the information in the matters that's being presented to you. And one thing I talk about with our clients or with people I meet with, I said, what your job as a director, when you sit at your table, your board meeting table, you're making your business decisions, you want them to be fully informed. And fully informed means you're collecting information. It could be from a committee. It could be from your fellow directors who did some research. It could be from your business advisor, your management team. It could be from your legal advisor, your financial advisor, your insurance advisor, these experts. But you want to gather as much information on the subject matter as possible so that you are then making what's called a fully informed business decision. Now, whether that business decision whether a third party would say that's a good decision or a bad decision, that doesn't mean if it's if it turns out to be not the best decision, if it's a reasonable business decision, that's business judgment. And you're entitled to that. And as the bottom line is a court is not supposed to step in and substitute its business judgment for yours. And there's a line of cases on that. So what we're talking about in the prior slide is establishing business judgment. A director is not acting in good faith if he or she has knowledge concerning the matter in question that makes reliance on those prior, on a officer, director, committee member, or professional unwarranted. Okay? But you will not be liable for any action taken as a director or any failure to take action if you performed your duties of office in compliance with this section. So 617.0830 is a very relevant section. Okay? So now I want to talk to your managers a little bit. Okay? These are standards for managers, and this comes under chapter 468, and this is section 0.4334. Okay. A community association and these were added to the statute not recently, but not they haven't been in there for decades. I do remember these being put in. I think Jason, I don't remember in the last 10 years maybe. A community association manager and a community association management firm shall discharge duties performed on behalf of the association as authorized by Chapter 468, loyally, skillfully, diligently, dealing honestly and fairly, in good faith, with care and full disclosure to the association, accounting for all funds, not charging unreasonable or excessive fees. Indemnification to a manager or management firm may not cover any act or omission that violates criminal law, derives an improper personal benefit either directly or indirectly to the manager or management firm, is grossly negligent, reckless, in bad faith with malicious purpose, or in a manner that exhibits wanton and willful disregard of human rights, safety, or property. Okay, so those are pretty specific guidelines that all managers and management firms are required to follow. Okay. Now, this next slide I want to highlight. Okay, there is a bill that has been signed by, a bill that has been passed in the House and the Senate. It is waiting to go to, it's actually gone to the governor. Nope, this one is not, right, Jason? 1021 is not yet?
Sorry, I lost my mute. No, 1021 hasn't gone yet.
Right, 1021 is still waiting to go to the governor. But if this bill goes to the governor, when this bill goes to the governor, at this point, we're expecting that he will sign it, and it will take effect July 1st of this year. And so I want to highlight, if HB 1021 is signed into law, this language that I'm about to read becomes in effect. So technically, as of today, it's not, it doesn't come into effect till July 1st, but as of right now, it's not been signed, but we have every expectation it will become the law effective July 1st. So do understand, managers, a manager or management firm, including directors, officers, and persons with a financial interest in that firm, or a relative of any person, must disclose to the board of an association any activity that may reasonably be construed to be a conflict of interest. And the statute will go on to add a rebuttable presumption of a conflict of interest exists if any of the following occurs without prior notice. Okay, that's a common theme, without prior notice. A, community association manager or management firm, including directors, officers, or persons or any person with a financial interest or relatives of those persons, enters into a contract for goods or services with the association. If they do, that doesn't mean they can't do it. It means if they do it without notice, there's a rebuttable presumption there was a conflict of interest. If a manager, management firm, directors, officers, persons with a financial interest, or any relatives of those holds an interest in or receives compensation or anything of value from a business entity conducting business with the association or proposing to enter into a contract or other transaction. Okay. If the association receives and considers a bid that exceeds $2,500 to provide a good or service other than community association management services from the manager or management firm, the association must solicit multiple bids from other third-party providers. So going back, A and B, these are two areas that a rebuttable presumption of conflict will exist if any of the following occurs. So if the manager or management firm enters into a contract for goods or services, or holds an interest or receives anything of value from a business entity that proposes to enter into a contract or transact with the association. In either of those scenarios, if there's no prior notice, we have a rebuttable presumption that there's a conflict of interest that exists. Okay? Further, if the association is considering a bid that exceeds $2,500 from the management company to provide a goods or services other than management services, The association will be required to solicit multiple bids from other third-party providers for those goods or services before you can accept the bid from the management company. If a community association manager or management firm, including any of those relatives and officers, directors, etc. I've talked about, proposes to engage in an activity that's a conflict of interest as described here in number 1, the proposed activity must be listed on, and all contracts and transactional documents related to the proposed activity must be attached to the meeting agenda of the next Board of Administration meeting. So what you see is what they're saying is you need to provide prior notice, managers, management companies, if there's a potential conflict of interest. If you're going to enter into a contract with them for services other than your management services, or if you're involved with a business entity that's entering into services or proposing to enter into services, then you must list the proposed activity on the meeting agenda, and any contract and transactional document has to be attached to that meeting agenda. Excuse me. The disclosures of a possible conflict of interest must be entered into the written minutes of the meeting. And approval of the contract, including a management contract between the association and the manager or management firm, or any other other transaction that we're talking about, requires the affirmative vote of 2/3 of all directors present, not just a majority. Okay, so this is going. If this takes effect on July, if it gets signed and takes effect as of July 1st, you need to understand these are the requirements on contracts that you'll enter into going forward. And at the next regular or special meeting of the members, the existence of that conflict of interest and the contract or other transaction must be disclosed to the membership. Okay, so at the board meeting, you'll have to have it on the agenda, and you'll have to have the contracts or transactional documents attached to the agenda. 2/3 of the directors present must approve it, and then at your next regular special meeting of the membership, the existence of the conflict of interest and the actual contract or transaction that was approved by the board must be disclosed. Okay? If the manager or management firm has previously disclosed a conflict of interest in an existing management contract that's been entered into already between the board and the manager or firm, the conflict of interest does not need to be additionally noticed and voted on during the current term of that management contract. But upon renewal, even if it's an auto renewal term, it must be noticed and voted in accordance with this subsection. Okay, so again, this isn't in place now, but as of July 1st, it's likely to be in effect. So management companies, management companies, be aware of this. Board members, be cognizant of this and get with your general counsel to make sure, I encourage all parties involved, get with association general counsel to make sure these are being followed properly. Okay? If the board finds a manager or management firm has violated this section, the association may cancel its management contract. And if the contract is canceled, the association will only be liable for the reasonable value of the services provided up to the time of cancellation. There'll be no termination fees, liquidated damages, or any other form of penalty. So if you don't strictly follow those requirements that I had on the prior slide, then the association the board can then say, well, now that we know, we're terminating the contract and there is no early termination penalty, no liquidated damages, or any other form of penalty. If an association enters into a contract with an association management or a firm, including those other parties, which is a party to or has an interest in an activity that's a possible conflict of interest, as was described 2 slides ago in subsection 1, and the activity has not been properly disclosed as a conflict of interest or potential conflict of interest as required in this section, which I talked about in the last slide, the contract's voidable and terminates upon the association filing a written notice terminating the contract with its board that contains the consent of at least 20% of the voting interests. So let me clarify what this is saying. Okay, so if the board finds out that there was a conflict of interest that wasn't properly disclosed, the board can terminate the management contract. And the association is only going to be liable for a reasonable value of the fees. If the board enters into a contract with a manager or management firm, and those conflict of interest disclosure requirements were not followed, and the board approved the contract anyway, but it wasn't disclosed. It wasn't talked about in the board meeting or the member meeting. 2/3 of the board didn't approve it. 20% of the voting interest of the membership could cancel the contract. So there's two ways. So that's why it's very imperative that these requirements be followed. Okay. And this will sound familiar in a little bit, because when I talk about board members, you're contracting if you remember my landscape lighting example from earlier, if a director or officer is going to contract with the association for a company that they either own or have financial interest in, very similar requirements are going to be in place with some slight changes. So we'll get into that. But for the most part, this is where this is coming from. Okay. Relative in this, as used in this section, means within the 3rd degree of consanguinity by blood or marriage. Good news, I have a slide in the materials later, which spells out exactly what 3rd degree of consanguinity means, because I looked it up. All right. As far as what is it, quickly glancing at some of the questions, what is a prudent number of bids? James, if you're asking that question in response to what they said, multiple bids means more than one. If you have so in that example, if it's in excess of $2,500 and you have a bid from the management company for a product or service unrelated to their management services for over $2,500, I would think you'd seek at least 2. And I guess legally, and again, my job is to provide legal advice. By the way, something none of us said, it should have been said. I am not providing legal advice today, guys. This is informational. It's educational. So the information I'm presenting to you here is not to be taken as legal advice for any of your communities. Please do follow up with your general counsel. Obviously, if you're looking for general counsel, there's some information at the end that you could certainly reach out to us. But in this case, it's informational, guys. So business Jason, you can jump on this, but legal, yeah. I'll add the legal advice. When its statute says multiple bids, it means more than one. It does not mean that you need a minimum of 3 or 5, etc. But I will pass to Jason for business advice.
So I agree with you, and I think that you have to play with that letter of the law thing. It's definitely multiple is 2. I agree with you. The rule of thumb has always been 3 for most things, so that you can start to get some perspective. But we have to also be, intelligent in our field, right? There may be only two organizations that are the right choice for the project you're working on or the item you're working on. And as long as you're legally sufficient, I think you're fine with that. It's more about finding the right partners to bid on something rather than just getting that mythical 3rd bid that people seem to think is necessary.
Okay. All right. So let's go back to the slides, and then I am looking over your questions. The question someone asked, can the LCAM's assistant be on the board if she owns a unit in the community? The short answer is yes. Okay. Owning a unit in the community doesn't automatically result in a conflict of interest. That doesn't mean there might not be conflicts of interest, and a conflict of interest that's even perceived is problematic. But there's nothing that would legally preclude the LCAM's assistant to serve on the board, as long as she otherwise qualifies for serving on the board.
But I think that goes back to your earlier conversation. The whole spirit is disclosure and putting it out there. So.
Okay. There's some good questions here, guys. So listen, I'm going to go through these materials. If I see any, if I catch any that seem to be tied in with what I'm talking about, I'll try to hit it. But otherwise, we'll take a few minutes at the end and we'll try to go through as many of these as we can. So I'm happy to stick around an extra 5-10 minutes if you listeners are as well. Okay, director liability. An officer, director, again, this is chapter 617. It applies across the board. An officer, director, or agent shall be liable for monetary damages as provided in this section if they breached or failed to perform their duties and the breach or duties constitutes a violation of criminal law, a transaction from which the officer or director derived an improper personal benefit, which could be directly or indirectly, or constitutes recklessness or an act or omission in bad faith with malicious purpose, or exhibiting wanton and willful disregard of human rights. Okay, so it could be liable for you will be liable for monetary damages in those instances. Okay, this now criminal activity and removal from office. Okay, 718-111, Section 1D. It was in the statutes for several years. Effective October 1st of last year, 723-033, subsection 4 came into play. So this now applies to both the condo and the HOA. An officer or director charged by information or indictment with forgery of a ballot envelope, or in the and the reason it's in red is because that was the HOA section that says, or voting certificate in the HOA law. Theft or embezzlement or refusal to allow access to official records in furtherance of any crime or as obstruction of justice must be removed from office. So if you've been charged by information or indictment with forgery of a ballot envelope or voting certificate, or theft or embezzlement, or refusal to allow access to records in furtherance of a crime or to obstruct justice, you must be removed from office. If a criminal charge is pending against the officer director, they may not be appointed or elected to a position as an officer director of any association, nor have access to official records of any association except pursuant to a court order. If the charges are resolved without a finding of guilt, they must be reinstated for the remainder of their term, if any. So that's pretty straightforward there. Okay, let's talk about some improper personal benefits. Again, this is in both 718 and 720 now. We're talking about improper personal benefits, also known as kickbacks. An officer, director, or manager may not, again, this is officer, director, or manager, may not solicit, offer to accept, or accept anything or service of value or kickback for which consideration has not been provided for his or her own benefit or that of his or her immediate family from any person that's providing or proposing to provide goods or services to the association. Pretty straightforward. Any such officer, director, or manager who knowingly so solicits, offers to accept, or accepts anything of service or value is subject to civil penalties and, if applicable, a criminal penalty. Okay? HOAs, you're going to be subject to civil penalties provided in 617 and effective October 1st, 2020. That took effect October 1st, 2023. House Bill 1203, which is an HOA comprehensive bill, which is on the governor's desk, and he is expected to sign it any day. There will also be criminal penalties facing HOA directors or officers and managers as well. So this is now what they've done the last couple of years in Tallahassee is kind of try their very best to mirror the Condominium Act and the HOA Act when it comes to conflicts of interests and irregularities that would be subject to civil and or criminal penalties. Okay. Now, this does not prohibit an officer, director, or manager from accepting services or items received in connection with trade fairs or education programs. And HOAs the statute actually specifically permits an officer, director, manager to accept food with a value of less than $25 at a business meeting. Well, very specific. Perhaps they need to raise 25 to a little bit to maybe 35 now. Conflicts of interest and interested transactions. Okay. How broad is the definition of a conflict of interest? A conflict of, and this may address some of your questions about realtors, etc. But I will get into that if I have a moment at the end. A conflict of interest exists whether it is real, it currently exists, potential, it may arise given the circumstances, or perceived. Members could reasonably believe a conflict exists or could arise, which may improperly influence the property manager or board member's performance of his or her duty to the association now or in the future. Let me stop there for a second and say, perceived is that's quite broad, in my opinion. And the fact is, that's a difficult standard potentially to overcome. Let's use a couple of you up front asked about realtors. If a board member is a realtor, can they vote as a board member on changes to leasing regulations? As a realtor, if a realtor serves on the board, does that constitute a conflict of interest? Well, in my opinion, no. The fact that someone holds a real estate license does not raise to the level of a conflict of interest that would preclude them from serving on the board if they're otherwise qualified. there might be situations where if they're actively involved in a business transaction with a unit, for example, that might result in a potential conflict of interest that would require them to perhaps recuse themselves from conversations, abstain from voting. But no, just the fact that someone is a realtor, in my opinion, doesn't automatically would not exclude them from serving on the board. Now, that's from a legal standpoint. Whether the membership believes that someone who's a realtor should or shouldn't be on the board, that's the membership's decision when they're voting to decide who's going to be on the board. Okay. Whether they vote, so voting as a board member on changes to leasing regulations. Again, as a director, and we talked about this before, but let me reiterate, when you are an owner in the community, you have your owner hat on, and you can be as selfish and self-interested as you'd like, hopefully respectfully so, and hopefully with an understanding that there are those who have volunteered who are taking a bigger picture. But once you volunteer to step up on the board, you have to turn that personal owner hat sideways and move your director officer hat forward. And you are now making decisions that you have to reasonably believe are in the best interest of the association as a whole, not necessarily your self-interest. Hopefully your self-interest and the association's interest are in line, and that's great. But if not, you need to be if you're choosing to volunteer, your fiduciary duty is expected to be to the association as a whole. So if your example is, hey, we have leasing regulations that are being proposed. Well, as a director, if your background's in real estate, you may have certain positions that are based on some empirical information that you have in your career to say why certain regulations would be good or bad, would be positive or negative for the community. And you can certainly share those but ultimately, going forward, you should be voting on what you think would be in the best interest of the association as a whole, not necessarily your own self-interest.
Yeah, it goes back to your first slide, Michael. This is a corporation, and that's what people have to keep remembering. It's hard for us as homeowners to step away from that, but it's critical. You have to act in the best interest of this association that is a corporation.
Right, and it's not always easy.
No.
But ultimately, when you step up to volunteer, that is your expectation. That is your fiduciary duty. So 617.0832 is your director conflict of interest. We talked earlier, tab 468, the manager and management company conflict of interest. Now we're getting into the director conflict of interest and disclosures that are required. The conflict of interest is made known to the board of directors or committee. It's made known to the membership, and the contract or transaction is fair and reasonable to the association at the time the board and or membership, if that's necessary, approves it. Okay, so remember these three disclosures. It's made known to the board or committee, and Jason, you highlighted earlier, it's notice. It's one of the first things we talked about on the slide as well. If you're doing these things without notice, that's where you're going to run into problems. If you're being above board and being transparent, then the objective here ultimately should be that the quote unquote conflict can be explained, and ultimately the rest of the board can make reasonable business decisions to approve, because they believe ultimately it's still in the best interest of the association. I'll use this landscape lighting example because it's something that I personally dealt with in the community that I'm familiar with, where the president of the association owned a landscape lighting company. And that association had landscape lighting that they were very dissatisfied with. And the president said that I'd like to make a proposal, and the president's company did. And they did, in this case, the board also got other bids. And ultimately the board did hire the president's company, and the president's they were very satisfied with it. The price was fair. It was a lot more actively involved and really cared about the landscape lighting. The community looked a lot better. I'm not saying that's always the case, but ultimately, what I'm pointing out is it's not necessarily just because there's a conflict of interest doesn't mean you can't have it. It means you have hoops that you must jump through, steps that you must strictly follow to make sure that what you're doing is in line with what the statutes now require, so that you and to ensure that everything is being done properly. And again, These are issues that can get a little bit complicated. You're going to want to rely on business guidance from your business advisors, your management team. You're going to want to get advice from your general counsel. Remember one of those slides earlier said you can rely upon your opinion of your attorney when making your business decisions. That is using your business judgment. Okay. So now I'm talking about 718-3027, which is your Condominium Act conflict of interest, interested transaction section. So now for you condo board members, directors and officers of a board of an association, not a timeshare, and the relatives of the directors and officers must disclose to the board any activity that may reasonably be construed to be a conflict of interest. Okay? A rebuttable presumption of a conflict of interest exists if any of the following occurs without prior notice. Okay? And this sounds familiar, right? This is very similar to what we talked about earlier with the management companies. Okay? Without prior notice. If a director, officer, or relative enters into a contract for goods or services with the association. If they hold an interest in a corporation, LLC, partnership, or any other business entity conducting business with the association or proposing to enter into a contract. Okay, so these are pretty much verbatim what we added in the management section if that law gets signed by the governor. Okay.
But these exist today, guys. Make sure you
This 718-327, this conflict of interest for directors, this is in the law, has been the law for several years.
Yeah.
Yes. Okay. So again, sounds familiar. If a director, officer, or relative propose to engage in activity that's a conflict of interest, as I just described in the prior slide, the proposed activity must be listed on all contracts and transactional documents must be attached to the meeting agenda. The association complies with 617.0832, and those disclosures are entered into the written minutes of the meeting. Remember, that was disclosure to the board and/or committee, disclosure to the membership, and a fair and reasonable contract. Okay? Approval of the contract requires the affirmative vote of 2/3 of all other directors present. So I, as a director, pitch my company to be hired. The board has a couple of other bids they're comparing to. Okay, so I then can present I will make the pitch. And then I will be, and I'll get to that in the next slide. At the next regular or special meeting of the members, the existence of the contract shall be disclosed to the members. Okay, so 2/3 of the non-interested directors at the board meeting have to approve a contract with the interested directors company. If the board decides they're going to go with a different company, it's only a majority, unless your documents require a different vote percentage. But you need 2/3 to approve the interested directors company, majority otherwise. If you go with the interested directors company at the next regular or special meeting of the members, the existence of the contract or other transactions disclosed to the members in the membership meeting minutes, and upon motion of any member, the contract shall be brought up for a vote and can be canceled by a majority vote of the members present. If the contract is canceled, the association is only liable for the reasonable value of goods and services, and there's no other penalties or liquidated damages. So this is a little bit different than the manager section. What this is saying is if you follow all proper notice requirements, if you're an interested director or officer or relative of, and you follow all the proper notice requirements, and you get 2/3 of the directors present to approve, at the member meeting, if a motion is made by any member, then a majority vote of those members present can vote to say, hey, we're going to cancel that contract anyway. Okay. That is not something that was part of they didn't have that ability to do with the manager's contract. Okay. If the board votes against the proposed activity, the director, officer, or the relative must notify the board in writing of your intention not to pursue the proposed activity, or you're going to withdraw from your position on the board. If the board finds an officer director violated this subsection, the officer director shall be deemed removed from office, and the vacancy is filled according to general law. I want to highlight one thing here, guys. Whenever there's a couple of areas of the statute where it says if the board finds an officer director has violated a subsection, the officer's deemed removed from office. My recommendation here is that if there are directors who believe that another director has violated this subsection, Before you unilaterally remove them, make these allegations and remove them from office, confer with your general counsel. Share all the facts with them. Let them give you proper guidance so as to avoid any unnecessary liability exposure to the association. All right, that's a practice tip. Okay. All right, now, if the director, officer, or relative has an interest in activity that's a possible conflict of interest, as described in a couple of slides, subsection 1, this is what I was talking about. They may attend the meeting at which the activity is considered by the board, and they're authorized to make a presentation to the board. However, after the presentation, the director, officer, or the relative must leave the meeting during the discussion and the vote on the activity. They recuse themselves from the vote and leave the room. So I present why you should hire my company. Thank you for listening. I then leave the room. My competitors then present why you should hire their landscape companies. And then the board can then discuss and make a decision on voting to either hire my company, 2/3 the remaining directors, or one of the competitors, the majority. Okay? A contract entered into between a director, officer, or relative, which is not a timeshare, that has not been properly disclosed as a conflict of interest as required by 718.11.12G, is voidable and terminates, again, 20% of the voting interest submits a petition, if you will, to the board. So this is very much like we talk about with the manager contract. If you don't follow the disclosure requirements, the 20% of the membership would have the ability to cancel the contract. If you do follow the disclosure requirements, the manager contract cannot be canceled other than by the board. The membership can vote by a majority of the members present at a quorum of the membership to cancel at the a membership. So there's the difference. Okay, and this is condominium. Okay, here's that slide that tells you what third degree of consanguinity is, so you can refer back to that. I want to now get onto HOAs, interested transactions. Okay, some overlap, not completely the same. Okay, if the association enters into a contract or other transaction with its directors or officers, you have to also comply with the requirements of 617-0832. Enter the disclosures into the written minutes. Those are the same as in the Condo Act. And also approve the contract or other transaction by affirmative vote of 2/3 of directors present. So those are the same. At the next regular or special meeting of the members, disclose the existence of the contract to the membership. And again, upon motion of any member, the contract shall be brought up for a vote and canceled by a majority vote of the members present. Again, if that happens, no penalties. All of this is exactly the same as we just talked about in the Condo Act. Okay? Some minor changes here. Directors and officers must disclose to the association any activity that may be reasonably construed to be a conflict of interest at least 14 days before voting on an issue or entering into a contract subject of a conflict. And a rebuttable presumption exists if, these are familiar to you now, you are the director, officer, or relative enters into a contract for goods or services, or they have an interest, a financial interest in a corporation or other business entity that enters into or proposes to enter into a contract. Okay, these took effect last year. There is no mention of third degree of consanguinity, by the way, in the HOA Act. So that means it could any relative. Directors and officers of an association appointed by the developer must disclose to the association their relationship to the developer each year in which they serve. And they also must disclose any other activity may reasonably be construed to be a conflict of interest. However, a developer's appointment of an officer or director does not create a presumption the officer or director has a conflict of interest with regard to the performance of their official duties. Okay. So the following act, among others, constitutes grounds for which disciplinary actions may be taken by the DBPR. Contracting on behalf of an association with any entity in which the licensee has a financial interest that is not disclosed. So before I hit the slide, so just concluding the last section of slides. So that was I did the manager disclosure requirements earlier. And then I just did the condominium and HOA board member disclosure requirements if you are considering entering into a contract with a director officer to provide goods or services. They are not strictly prohibited. That was stricken out of the, it was never in the HO Act, and was, well, I shouldn't say that. There was some language in the HO Act which was confusing, which is not there any longer. The Condo Act, that was stricken. There is now specific conflict of interest guidelines, which I've just given you a summary of. It's in your slides, that I've gone over and hopefully given you some better understanding of what that is. And encourage you, of course, to follow up with general counsel and business advisors if these issues come up for you personally. So now, moving on to the next section, back to managers for a moment. If you don't provide, if you have a financial interest in an entity and you don't disclose it, that also can result in disciplinary action with the DBPR on your license. Okay. All right. We have just, I think we're down to just a few more slides. So let me get into special restrictions for condominium associations. Okay. Let's see how we're doing. All right. We're doing pretty good on time. Strange, guys. I taught this class a week ago. It was in person, and it's a little easier when you're back and forth. Here, I hope you're all enjoying. No maintenance or management service contract is valid or enforceable unless it discloses financial ownership interest of the developer, if the developer is in control of the association, or discloses any financial ownership interest a board member or any party providing maintenance or management services holds with the contracting party. You can see the Jason, right? The constant theme here is disclosure, disclosure, disclosure.
It's all disclosure, transparency, which seems, it's a great thing to have, and it's one of the things that Tallahassee is pushing us. So get used to it.
Okay, right. An association may not hire an attorney who represents the management company. It's pretty straightforward. So management companies would have their own corporate counsel. The association's general counsel does not represent the management company. Now, just to clarify, that doesn't mean that there aren't situations where the association's general counsel will not also be stepping in and offering, if you will, defending the manager or management company. That's comes under the indemnification language in a lot of management contracts. By way of the simplest example is when you have a manager or management company that is named in a complaint through the division and or might even be a legal action, then typically if there's insurance defense that steps in, they're going to step in and defend both the manager, the association, and the management company, unless there's some reason that there would be a conflict between those two parties, and that would be technical and be addressed. But an association may not hire an attorney that represents the management company as their general counsel. Straightforward. There's no limitation on the association's right to purchase a unit at a foreclosure sale that results from the association's foreclosure of its lien. However, other than a timeshare condominium, a board member, manager, or management company may not purchase a unit at a foreclosure sale that results from that foreclosure. Okay? A party contracting to provide maintenance or management services to an association managing a residential condominium after transfer of control. Okay? An officer or board member may not purchase a unit at a foreclosure sale resulting from the association's foreclosure. So it sort of reiterates that first part. Okay. Debit cards. Okay, now debit cards has been in the Condo Act. It is going to also now apply to HOAs if House Bill 1203 is signed by the governor as expected. So this is applying to the condo now, effective July 1st. If 1203 is signed, HOAs, this applies to you as well. An association and its officers, directors, employees, and agents may not use a debit card issued in the name of the association or billed directly to the association for the payment of any association expense. Okay. Here's what I love about our friends in Tallahassee. So the first bullet point, right? An association, its officers, directors may not use a debit card. Second point, if you do use a debit card, okay, in the name of the association or billed to the association for any expense not a lawful obligation, it may be prosecuted as credit card fraud. That's in the Condo Act currently. If House Bill 1203 is signed as expected, that credit card fraud is going to be changed to civil theft. And also the person using the debit card must be removed from the office and a vacancy declared. Lawful obligation is also defined in 718 and 720 as an obligation that has been properly pre-approved by the board and reflected in the meeting minutes or at the written budget. Okay, and all of that, that's in the 1203. That bold section there will be at 1203. Once 1203 is signed as we expect, no use of it. So quickly summarizing, don't use a debit card. Just cut them up. You know, this is not prohibiting the use of a credit card for an association credit card. It's precluding a debit card. So if you need to use one, using a credit card, and if you're going to use a credit card, please make sure you have a well-documented receipts, invoices, all of those things that support any reimbursement that you might get from an association credit card. But quite frankly, it's the association credit card would be better served to be paid from the association just paying the bill, and then every charge on there having complete and proper backup to reflect that it is these are properly authorized expenses for the association, and that someone's not going to question that these are personal expenses. So just be very, very cognizant when you're using any sort of, you know, if you're using an association credit card. Don't use a debit card is my advice. All right. Okay, now, last October 1st, HOA Bill of Rights went into effect. This was directly in response to the matters that have been going on in the hammocks down in South Miami, which truly is an egregious example of alleged criminal activity. I mean, I guess there's no other way to put it, Jason.
Yeah.
You know, but it's a very, hammocks is a huge community. It was very public. And I'm not suggesting that some of the things that went on there aren't happening in other communities, but overwhelmingly, it's not something that I see. But this has now been legislated in the state. So each of the following acts is a fraudulent. This is in effect now, effective October 1st, 723.065. If House Bill 1021 is signed, and this is the condo bill that has not gone to the governor yet, but if it gets signed, then effective July 1st of this year, everything I'm talking about now will be in 718 as well. Okay, so each of the following acts will be a fraudulent voting activity, and it constitutes a misdemeanor of the first degree. Okay, which means it's punishable by certain penalties and potential incarceration. Willfully and falsely swearing to or affirming an oath or affirmation, or willfully procuring another person to falsely swear to affirm an oath or affirmation in connection with arising out of voting activities. I'm not going to read each one of these guys. I gave them to you on the slide, but these are all essentially fraudulent, but these would be considered fraudulent voting activities. You know, if you're perpetrating or aiding in the perpetration of fraud in connection with the casting of a vote to be cast or attempted, preventing someone from voting or preventing them from voting as they intend, by fraudulently changing or attempting to change a ballot envelope or voting certificate, menacing or threatening or using bribery to influence a vote, giving or promising directly or indirectly anything of value to buy a vote, okay? Using or threatening direct force indirectly or use the use of force directly or indirectly to intimidate or compel or coerce a member to vote or refrain from voting. All of these things are very bad acts. And if you are found to have committed them, then you will be punished by a misdemeanor of the first degree. Okay, a little warning for you. Okay, I'm going to wrap up with a couple of just practice tips, and Jason, feel free to jump in. Okay, everyone is doing it is not a good reason for you to do something. Do not ignore an activity simply because it may be commonplace. Okay, do not evaluate competency or ethical standards solely upon your budget. Compare your progress to your stated goals. Do not refuse or be hesitant to obtain professional advice. And I don't just mean your lawyers, but of course your lawyers come into play a lot more than you probably use them. But you have your business advisors, but you have your insurance advisors, especially these days. Communicate with your insurance agents. These are the experts in the field. Get in for, meet with them and understand what your insurance is and isn't, what your endorsements are or aren't, what exclusions may or may not be there. Get a better understanding of, and a cost-benefit analysis of what's out there. And understand. Go ahead, Jason.
That one's huge because insurance is changing so rapid. I think it's we were talking about it this morning at another thing I was at, and we're paying more for less coverage, and you need to understand what that is so that when you're making those decisions, you're using it. But the point is, use your experts, talk to your engineer, talk to your property manager, talk to your all of these people that can give you advice. You can't know everything.
Right. Okay. And you need to, the directors, you have to understand your rules, your governing documents, and the importance of compliance, uniform compliance. Okay. Disinterest in members. Directors need to be cognizant of the community. I emphasize this all the time. Reject the me versus them. Okay. Remember, as a director, as I mentioned earlier, remember you turned your owner hat sideways, put on your director hat. Every decision you are making, which you believe to be in the best interest of the community, impacts you as an owner. And owners need to, and sometimes that can get lost. So when you are up there making decisions, sometimes those decisions are not popular, but help the membership understand that you're making these in a way that you believe to be best for everyone. If it was up to you, you wouldn't want to necessarily have this special assessment, but you need to do these projects, for example. And in terms of when you're discussing that, don't say, for example, special assessment. So you will need to pay blah, blah, blah. No, we will need to pay because it's impacting me the same way it's impacting you. So try to remember to reject me versus them. This kind of helps avoid certain conflicts between the board and the membership, which is kind of the tie-in here to the conclusion of my project. We kind of went through all of with emphasizing conflict of interest with managers, with directors and officers. Really highlighted those, highlighted the new laws in particular regarding voting, impacting of voting. And so I'm kind of just concluding now with some tips. You can't simply act unilaterally because members have historically ignored operational issues, guys. The fact that I understand there's apathy, but if the governing documents or the law requires that you get membership support, you need to go out and get that membership support. And like the best example I can give you on this one is I have, communities who say, hey, they want to borrow. And I can't emphasize enough the importance of coming to your general counsel early on in the process to find out, hey, do we need a membership vote for borrowing? And if your documents say you need a member vote for borrowing, and then I hear, well, we can't get the membership to show up, no one's going to vote, this, that, and the other thing. And I said, I understand. All you can do in that instance, though, is emphasize to the members, we have necessary maintenance projects we must do, and we must pay for them. So we need $500,000, and we need it in the next 6 months. Or $5 million in the next 6 months, who knows? We can do it one of two ways. Some of you might be in a position to pay lump sum on that, and God bless. But a lot of us, hear how I'm saying that you and us are not. So we can, if you can approve, we need your approval to get a loan or a line of credit so that we can give us options to either pay lump sum without paying interest, or for those of us who'd like to borrow and pay it out over time, we can do so. If you don't approve that, we will have no choice but to hit everybody up with a large special assessment. So we encourage you to support. So yes, apathy in members, but that's the way you have to then work with your membership to try to help them understand that this is something being offered in the best interest of everybody, the community as a whole. It's just a simple example. All right. I had to get a picture of a doggy in there.
You missed a good one though, Michael. We've always done it this way. There's another warning sign. You can't say that we always did it this way. That doesn't mean it's right. You really have to take a look at, how it should be done, and especially considering some of the changes we're talking about.
Right. I guess that was the everyone is doing it kind of spin off on that one. But yes, good point. Yeah. Very good point. All right. Lastly, some general best practices. 2 slides on this. Board engagement. Specify limits of delegated authority and document approval for large or out of ordinary expenditure. Obtain competitive bids on a periodic basis. Retaining bids and compare notes. Discuss pros and cons of service providers at board meetings. And these are things that you need to get with Jason, his team, or your business advisors, and really be cognizant of these things. I'd recommend you always use licensed and insured contractors. Okay, and to maximize legal protection and minimize your risk, document. Have written policies that govern collection and enforcement. Document appointments to committees or any delegation of authority. Mentioned this earlier, expense reimbursements or use of petty cash to avoid any claim, any sort of issue there. Delineate between corporate and personal documents. Inventory the records on an established periodic basis. and have clear conflict of interest and interested transaction policies, which should be in line with what we talked about today. Okay? Obtain adequate insurance coverage, guys. All right. So that is the course. Let me quickly go through some of these questions. Jason, I don't know if you've been looking at the questions too, if you want to jump in on them.
I was trying to. There were quite a few of them. Let me see which ones I think we should. So I think we talked about that. There's a number of them that you kind of addressed in theory a little bit. So it's an interesting one. I like this. If an attorney for an association writes an opinion telling them how something should be handled, according to 718, and the board is I guess, and the board, I think they're saying the board doesn't.
Well, right. So yeah. So anyway, so if the attorney for the association writes an opinion has something should be handled according to the docs and 718, is the board in breach fiduciary if they don't comply. Listen, that is Darice. If I mispronounce your name, I apologize. That's a great question. Not necessarily. Again, first of all, I know that I've given an opinion where it wasn't something that they were thrilled with, and they would go look for another opinion. So I mean, it really depends. I mean, if you get an opinion, the bottom line is if you're getting an opinion and you act in and you don't act in compliance with that opinion, I guess it really would depend on the scenario, the situation. As far as how the risk, it's not a breach of fiduciary duty if you don't agree with the opinion of your expert. Necessarily, it's not an automatic breach of fiduciary duty. But I think, Darice, even though the question is great, it would be the kind of thing that I'd say on a case-by-case approach, depending on what the facts are, what the opinion is being presented on, the exposure to the association. Could determine whether that would be considered a breach of fiduciary duty as well. Sometimes someone says, well, if we don't do this, what's the risk? And there's risk exposure. Someone files a complaint with the division. Someone decides to bring cause of action. There's a cost benefit analysis. There's risk assessments. And so there's certain facts and there's certain fact patterns, which I would say that if I give you an opinion that is the law, rock solid, supported by case law, and you decide to ignore it and that exposes the association, could that be considered a breach of your fiduciary duty? Potentially. Will that expose the director personally? I mean, not automatically, no. Again, remember, personal liability is going to be depending on, it has to be with so reckless, wanton, willful disregard to, so it's a pretty high standard.
So I think there's a lot of questions with.
Yeah. Let me just skim through these. Yeah, let me get quick through. Okay. Is the board member assisting an owner suing the association a conflict of interest? John, the bottom line is these guys, you're asking questions which require more fact gathering, and that would mean they're really more specific questions. So is a board member assisting an owner suing the association a conflict of interest? It depends on the facts of the case. Certainly, I've had situations where the association was being sued by an owner, and there was proof that there was a board member who was supportive of that owner, and therefore any sort of meetings with the attorney that would be closed meetings to discuss pending litigation would exclude that board member, because that board member has exposed that there is a potential conflict of interest in that the fact they're not keeping that they're at risk of breaching the confidentiality, giving up strategy, that kind of thing. So okay, is the conflict of interest of the manager of the HOA used to live in the community? Not in my opinion. I don't think that's not a conflict of interest. No, not in and of itself. Brenda, if you're asked to personally be in charge of the day-to-day management of the association with payment, okay? Well, for starters, if you are going to be providing management services for payment, you need to be licensed. If you're not a licensed CAM, then you should not be providing management services for payment. Okay? The multiple bid requirement pertaining to the management company was not for the management company's services. It was for a goods or services unrelated to the management company's services. Angela, I hope that answers your question, Angelina. If there's a tie vote, well, if you have an even number of directors and there's a tie, whatever the motion is on the table fails. Maria, if a board member is a CAM somewhere else but brings in a vendor, does that member need to advise the board? Again, the way you asked the question, it would, again, it would seem to be if the board member is a manager somewhere else, not at your community, are they an owner in the community? I'm not clear on what the connection is, but I guess I just emphasize the importance of disclosure.
I mean, Michael, there's a lot of those very specific questions, this case, that case, the other case. I think the takeaway really is disclosure, everyone. I mean, you know, you can never over disclose, I guess is kind of how I look at it. You know, when we get involved in stuff, we want to make sure that everything's out there and there's no, even as you said, perceived notion. So put it out there, put it on the table, put it in the minutes, and cover yourself.
Well, right, and again, the takeaway from the program really is really, for me, it's just to point out that what the law requires as far as conflict of interest, but really to emphasize, I get asked a lot, or I get told a lot, oh, they're in conflict, there's a conflict, and it really, there isn't, it's often not the case that there is a true conflict of interest that would preclude a board member from taking certain actions or participating in certain actions. I think it's just really a matter of getting it, I appreciate everybody here getting educated, and communicating with your professionals if you have certain questions. And again, err on the side of disclosure. Again, there should be nothing to hide, right? So open disclosure, lines of communication between management and the board, between the board and the membership, can only serve, in my opinion, generally speaking, certainly serve for a better running of your business, as the slide opened up with. And as far as the recent legislation on civil and/or criminal penalties, again, a lot of that was in direct response to the hammocks. A lot of those laws, to me, the people, these laws were not on the books when the individuals who allegedly committed the hammocks crimes were arrested and indicted, meaning they're still, the laws are already there. And this is kind of the position I had taken. These laws are already there. Do we need more specific laws which kind of like might spook people? And so I'm encouraging board members, don't be spooked. Obviously, you understand the do's and don'ts. The list of the things that the voter fraud, they're pretty specific and as far as the you need to be doing some pretty bad acting, and with criminal intent almost to be found. So don't let those scare you off. But if you have any follow-up questions on that, definitely do talk to your manager, talk to your attorney, and get a sense of peace, if you will, because you directors, you officers, you volunteers, you committee members, you're the lifeline, you're the bloodline of these businesses, and so keep up the good work.
Yeah, we absolutely need you out there. So
and
please
I know there was a lot of questions, guys, and that we couldn't get to, but very much appreciate you guys being here. And I see it's already 1:15, Jeff, so I will kick it back to you. Again, everybody, wishing you a good summer. Stay cool.
Good luck with that.
Good luck with that is correct. Great job, guys. Thank you both. Jason, thank you for having us. We appreciate that. We look forward to the next one. We'll be in touch with you. And folks, I know you guys have appointments to get to. Do what you got to do. I'm going to hang out. I'm going to go over the evaluation process one more time for everybody. So, parting words, gentlemen. Oh, Jason's gone.
Well, first off, I want to thank Jason. I want to thank Trident for hosting and helping us put this together. Look forward to doing more work with you guys, more education, things of that nature. Again, I want to thank everybody for listening. Kaye Bender Rembaum. We're a full service community association firm. We do a lot of education, as many of you know. We do appreciate you guys coming to our classes, both virtually and in person. And if we can ever be of assistance to your communities, you can hit us up at info@kbrlegal.com. In the interim, kbrlegal.com has a tremendous amount of educational materials as well, which are all free to access, including this class will probably be linked there at some point as well. So thank you all again. Jason, thanks. Jeff, be well.
You as well.
I'll just say thank you, Michael. We've worked with KBR and a number of associations that do great work for our clients, and it makes our lives much better as managers when we have a partner that can provide that advice and understands the law the way that it needs to be approached. Again, if Trident can be of any help to anybody who's here, please feel free to reach out. They're going to put up our contact information. Look forward to talking to you soon.
Thank you, Jason. Thank you, Michael. Have a great day, gentlemen. And I'll go over all the questions that are in there now about the slides and the evaluation.
Perfect. All right. Thanks. Bye-bye.
Take care, guys. And folks, I'm hanging out for a little bit. I'm going to open up the chat so you can send me technical questions if you have any. So let me go ahead and do that now. I'm going to place the link for the chat, for the evaluation in the chat one more time in case you missed it. Just hit enter. So it's there now. And what you do is I'm going to share the screen. I'm going to go over how you get all that. If you're on the phone, I see somebody asking you're listening, send us an email, info@kbrlegal.com. And in that email, let us know you were on this event via telephone. You were not able to see anything. And also provide the phone number that you are calling in with so we can match it up with the Zoom attendance sheet to be sure that that phone number is listed on there with full attendance. So I'm going to share the screen now. When you click the link in the chat area, and if you don't see the chat area, click the little chat button at the bottom of your Zoom interface, and then it'll show up on the right. Okay, that's where the link is. And if you don't see it there, you may not see it there if you haven't already done that. So the link, I just placed it in there one more time. Click on it. It takes you to this page here. You fill out this evaluation. It's not as daunting as it looks. It goes rather quickly. Then you hit submit. After you hit the submit button, the confirmation screen looks looks exactly like this. And this is where you can get two things: your certificate of attendance. You click here to download your attendance certificate. A new tab opens up. Here it is. You print it out, fill in your name and CAM license number if you're a CAM, and then you print it out and save it that way. Okay. Then underneath that, it says, many of you are asking for the slides. Click here to download today's slides. Click on the word here. And again, a new tab will open up. And then here are the slides. You can then choose to print them or download them. I always recommend downloading them because printing is going to use up a lot of toner and you'll be headed off to Office Depot pretty quickly for some new toner. And remember, if you go to Office Depot, don't use your association's debit card as they press during the presentation. Also on here, as Jason alluded to, is all of the contact information. Okay, you have the way to contact Michael, the way to contact Jason. The two organizations' websites are here. Phone numbers are here. So you can take a picture of this screen, save it as well, or visit the websites, whatever you choose to do. Let me check the chat if anybody's having any issues with the technology. Who can I contact to get my certificate from a life event? I don't know how to pronounce your name properly. I'll say Guillaume. Guillaume, email us at info@kbrlegal.com if I'm assuming you're alluding to a class at an expo or a trade show, those are handled by the respective offices. So send an email to the info, let us know the date and the event itself, and we'll get it to you there. Hitting the link doesn't open evaluation. You're welcome, Guillaume. I hope I said your name properly. So I just placed the link on there. Again, I'm going to test it out, and it opened for me. And I also have a couple of hundred people that have not had an issue opening it. Yeah, Jason said it works too. So what I can recommend, folks, if you're having issues, just drop us an email at info@kbrlegal.com, and we'll be happy to help you out. Mine does not say June 4th. If it says June 4th to enter, mine shows May 29th, but if it shows June 4th, just pick today's date. It will not affect anything. I promise you that. Don't worry about that. It's bizarre. Mine shows June 4th. Claims adjuster license. This is only for CAM licenses. This will not satisfy. This is approved for CAM license renewals. Thanks, Mary. Good to see you. Let's see. What did you say about phone numbers and email? When you fill out the evaluation, okay. See, mine says May 29th. I'm not sure why others, but whatever it says there, just enter today's date. But again, that's not going to affect anything. You just put today's date on there. Fill this out, hit submit. And I'm going to do this with everybody just to show you all how it works in the event that you're struggling there. Technology is wonderful when it works. Let's see here. Yes, 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 yes. Test. Name, CAM license number, boom, 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 boom. Not a robot. I'm going to hit submit. And then this screen opens up. This is where you have all the phone numbers, all the contact information. Click here to download your certificate. You click on that, then you can download and save your certificate. Click here to download today's slides. You can then download them or save them. And again, I recommend downloading them and saving them because printing them will use a lot of toner or ink. Links for the KBR website, a link for the Trident management website, what's coming up with the two organizations, phone numbers, email addresses, it's all right there. So let's see. Thank you. Got all the info. Thank you. Every time I fill out the form, you come on and I have to redo the form. Dorothy, not sure what that means. Save the link. And again, we're not unreasonable. We're happy to help. If you're having any issues, just drop us an email, info@kbrlegal.com. Mention you attended today's class and you had a little bit of an issue with getting the evaluation done, and we'll be happy to send you a link. We'll help you out there. I'll stay on for another minute or so. Let me put the link in the chat one more time. Evaluation link. You're very welcome, Dorothy. Thanks for hanging out with us, and thank you all for hanging out with us. We know you have choices and options, so thanks for hanging out here. Guillaume, it's info@kbrlegal.com. INFO. Thanks, Gary. INFO@kbrlegal.com. And just mention you were having issues with getting the certificate, the evaluation done. Correct, Janine. You print it out and you put your name in. This is just like as if we're at a trade show and we give you the certificate and you put your name in. Thanks, Marty. Glad it's working for you. The reason we had to do this is the DBPR now has stricter requirements for font size and type that has to appear on the certificate. And the way we were doing it in the past, when it forms your certificate on the screen, which many of you might be accustomed to taking courses with us in the past, is that when you print out your certificate, it all depended on the end user, meaning yours, printer settings. So sometimes you would print it out, the certificate would not have the proper typeface or proper 12-point font size for a certain part of the certificate. So to help ensure that, we made it as a PDF now where you download it yourself. Everything is the way it's supposed to be, the way the DBPR wants it. So that's why we did it this way. Maria, glad you got it done. Thanks for hanging out with us. I'm starting to recognize a lot of these names. I'll tell you, I feel like a bartender at Cheers. We have our regulars. So again, thanks for joining us. Okay, looks like the links are working for most everybody, but again, just drop us an email if you're having any issues and we'll be happy to help you out. Umberto, thank you. Mary, thank you. Laura, great. Thank you so much. And I'm just going to wait here to make sure that there are no more technical issues. Janine, you as well. Thank you so much. Have a wonderful day. Stay safe out there. Brenda, thank you. Appreciate that. And we appreciate all that you all do. It's not easy being a board member or a manager. It is not easy. Just keep smiling and remember, do the best you can and not take things personally. Usually folks are displeased with a concept or an idea, and it has nothing to do with we as people, and it's not always easy to remember that. Yeah, Guillaume, it's they're cracking down. We got to make sure we comply. Thank you, Sandra. And again, I'm just hanging out here just to see if you have any more questions or issues with the technical side of things. I'll stay on for one more minute. When Michael and Jason earlier were talking about putting a different hat on as a board member versus a homeowner who's not a board member, it made me think of Star Trek II, The Wrath of Khan, when Mr. Spock went into the dilithium chamber to knowing he was going to die to save the Enterprise so they can get away from the exploding planet. And what he said, I don't know if anybody put in the chat if you remember what he said, which is association living, a microcosm of association living. And what he said was the needs of the many outweigh the needs of the few or the one. And that is the first thing that came to my mind when Michael and Jason were talking about the different hats earlier. All right, I see no other issues in the chat. I'm going to sign off. Thank you, Guillaume. Have a great day, folks. Be safe out there, stay cool, and hydrate. That's all I could say is hydrate in this heat. Ciao for now, everybody. Bye-bye.